Hello, my name is Eric. I'm a co-founder of myhotworks.com, and today we have Bob with us once again, and this is a second video in this series. And Bob, how are you doing today?
I am good, Eric. How are you?
I'm doing great. And today's topic, we're going to cover some of the most common lawsuits facing the hospitality industry. What is your take on that?
Well, Eric, as you know, last time around we discussed the Fair Labor Standards Act, which does require all employers in the hospitality industry and otherwise to pay their employees at least federal minimum wage, and in some states there's a higher state minimum wage, along with overtime pay if any of the hourly employees works overtime. Now, we also discussed during that talk that certain employees are exempt from the requirements to pay overtime. These lawsuits about pay are very common, the most common in federal court. But today I'd like to switch gears and talk a little bit about the ADA, the Americans with Disabilities Act. Now, there's two parts to the ADA. One is accommodations of employees with disabilities in the workplace. The other aspect of the ADA is customers who visit your business for the purpose of purchasing products or services. This applies obviously in both the restaurant industry and the hotel industry. It's a very, very common lawsuit in federal court today, rivaling the Fair Labor Standards Act.
Great, I see. And what are the most common claims in ADA cases?
Good question, Eric. The most common claims that I see, both in restaurants and in the hotel industry, are claims based on failure to accommodate. And by that, I mean either the entrance way to your lobby of your restaurant or your hotel is not compliant for someone in a wheelchair, for example. In the hotel industry specifically, we get a lot of claims that hotel rooms and hotel room bathrooms are not compliant. Those are the most common claims. I also see, especially in the hotel industry, many claims that there is a failure to post the correct signs and parking lots, to have the proper number of ADA parking places. It's interesting. I think most people who are not in a wheelchair would say, well, it seems like there's ADA parking spaces all over every parking lot. And while that is often true, it is also true that often those parking spaces are not properly marked, or not the proper width or depth, or do not have an access aisle adjacent to the parking space, so a wheelchair could not effectively be taken out or rolled out of a vehicle because there's simply no space between that vehicle and the vehicle next to it. So those are probably the most common claims. And unfortunately, they can be expensive claims to rectify. So it is worthwhile to spend some energy and time to determine a compliance issue. The ADA does have certain regs and specifications that any business owner can look up or research. It is complicated. I will say it's a complicated endeavor unless you're familiar with the regs. Do that research on your own.
I see. So those the ones that you mentioned are mostly for guest-related or customer-related cases. How about some employee-related cases in regards to ADA?
Well, that's a good question. Many of my colleagues who represent business owners would simply say, look, if you have an employee that requests an accommodation, go ahead and make that and do that accommodation. And by that I mean if someone, for example, needs an ergonomic chair,
Mm-hmm.
certainly that's an accommodation that most employers could make. There are accommodations that are more difficult. For example, I have an employer that came to me, said, look, I have an employee that has a health issue.
Mm-hmm.
She has to take certain medication, which causes her to sleep during the workday. And my client said to me, I don't really have a problem if she needs to take a nap, but she snores so loudly it makes it hard for other employees to get their work done.
Wow.
So what we did was we found her, she had been working in a cubicle.
Mm-hmm.
We found her a cubicle that was more private. So that allowed her to take some short breaks during the day where she could go, whether she was napping or just
mm-hmm.
resting, whatever she was doing. But I think most of my clients who come to me
mm-hmm.
with employer-related disability issues,
mm-hmm.
we work hard to find some type of accommodation, even if it's not exactly what the employee had in mind.
I see. I understand. And how does it relate to pregnancy in the workplace? I know a lot of hotels or even in restaurants, you lift heavy trays. Sometimes in hotels, you lift heavy beds if you're in housekeeping. How does that relate to the pregnancy?
Well, that is a really good question. It's an area of the law that's relatively new and evolving.
Mm-hmm.
Obviously, any employee needs to be able to perform the essential functions of their job.
Mm-hmm.
So how do you accommodate someone, whether they're pregnant or maybe they have an injury which doesn't, mm-hmm. for example, allow them to lift anything above a certain weight? My clients will then attempt to accommodate them by finding other less strenuous work for them to do. However, I have also had clients that simply said, look, I don't have other types of work for you.
Mm-hmm.
And, went to the state, said, look, this person, maybe they're on disability leave, maybe they even qualify for unemployment benefits. My client didn't really have any interest in letting any person with a disability or pregnancy leave employment,
mm-hmm.
but simply did not have work for them. And to follow up, someone that obviously goes out on leave
mm-hmm.
due to pregnancy, again, most of my clients, I suggest, try to accommodate them, try to find them work.
Mm-hmm.
It could be the same job, it could be an equivalent job if possible when they return. That, again, especially for a smaller business, can be quite a challenge. If there's, if you have less than 50 employees, of course,
mm-hmm.
you're not by the Family Medical Leave Act. But, of course, the discrimination laws apply
mm-hmm.
to the businesses with fewer than 50 employees.
Correct.
So it's important to know what laws apply to your business and what laws don't. For example, don't tell all your employees that you're going to comply with the Family Medical Leave Act if that law doesn't actually cover your business because you're a
mm-hmm.
smaller business. That being said, I think most of my clients try to do the right thing and accommodate.
I see. Yes, that makes sense. Usually the best approach is to do the right thing, I think, in business.
I think you're right. I will say this, circling back just for a moment to, especially in the hotel industry, unfortunately, in the world of ADA cases, what
mm-hmm.
we have are what are called testers.
Mm-hmm.
And testers are individuals who are disabled that simply visit businesses for the purposes of trying to identify a violation of the ADA.
Mm-hmm.
So what I suggest to my clients in hospitality
mm-hmm.
and other industries is, look, start with what's obvious from the street. If I drive into your business, if I drive into your parking lot, if I see problems right away, if I don't see the right signs, if I don't see the right parking spaces, if I don't see the right ramps to get into your business, that's a signal to me, if I'm in that wheelchair, hey, this is a business that probably has other problems, whether it's a restaurant or a hotel. Your lobby, when I enter your business, do I see the proper height for counters?
Mm-hmm.
Do I see the proper width for doorways to accommodate my wheelchair? So my suggestion is always start from the customer's perspective, and try to eliminate barriers or issues on the way into the business.
Mm-hmm.
Because, my sense would be that if someone in a wheelchair immediately recognizes your business as one that is obviously compliant,
mm-hmm.
Looking from the outside, whether it's the parking lot or the lobby or the bathrooms,
mm-hmm.
Maybe that individual in a wheelchair goes down the road to the next business looking for violations and doesn't bother with you.
Mm-hmm.
And that's not to say that, I'm encouraging folks not to pay attention to this law at all, or not to accommodate in terms of having hotel rooms that are compliant. It's simply to say that these fixes can be expensive. Start with the ones that are going to help you mitigate the risk of a problem. Start there. I know I have some clients, some hotel owners in Orlando and elsewhere, and they've got it buttoned up. They went into their rooms.
Mm-hmm.
They spent a lot of money. But I would say they would welcome anybody with a disability and would never have a fear there was an issue. For many of my other hotel owner clients, who especially own hotels that are older, maybe built in the 40s and the 50s when the interstate system was completed, those hotels, it's very difficult for them to update. It's very
mm-hmm.
expensive. They have to move walls. They have to bring in engineers. So it can be a challenge and it can be expensive. And that's what I always say. If you get one of these cases, A, call an attorney.
Mm-hmm.
B, try to make the corrections quickly, because the folks that are making money in these cases usually are not the testers. They're not the folks in the wheelchairs. They're the attorneys, and nobody likes to pay attorneys, Eric. I can tell you that right now. Nobody wants to pay an attorney.
Yes, that's very interesting topic that you brought up about testers. Recently, I heard about a case where that's what it was. A tester came into a hotel and asked for special equipment for hearing impaired for the room, and of course, hotel did not have one ready to go. And when request was made, they were not able to provide it because they were trying to locate it and they couldn't locate it because such requests are not made very often. And later on, it was found out that the same person had filed about 25 different ADA cases within the state of Florida.
Yeah, Florida, unfortunately, Florida, New York, California are the states where you find by far the highest number of ADA cases. It's unfortunate, but I think that Florida as a vacation spot, there are a lot of, there's just a lot more opportunity for issues.
Mm-hmm.
And it's not uncommon for a single tester to have, as you said, 20 or more cases going on at any single time. It's, especially where you have an older building.
Mm-hmm.
In New York City, they get a lot of these cases, and it's very difficult for these business owners to accommodate these new regulations, simply because they're structurally, it takes a lot of construction, reconstruction and design to make those accommodations. So that's why my suggestion always is look at it from the outside. Maybe put yourself in a wheelchair, figure out what the challenges are. I do, and to be honest, Eric, I have some hotel owner clients. If anybody calls to make a reservation and they need, an ADA room, the answer always is, we're booked. And while I don't advocate that approach, I understand why they are extremely nervous, especially to your point in Florida, where there's a lot of this litigation.
Very interesting point. A very good insight. And what are some steps a hotel or restaurant can take to reduce the risks of ADA cases?
Well, I think that often what you have is someone comes into your hotel, for example. If, for example, you don't have the right height counter for someone in a wheelchair, my recommendation is always have that the person behind the counter walk out from behind the counter and pull a chair over next to the person in the wheelchair to fill out paperwork, etc., etc. Certainly, I think that the more cordial, the more accommodating, and I'm not talking about legal accommodation, I'm just talking about cordiality. Whether it's a hostess at a restaurant looking for a table where someone in a wheelchair can feel comfortable, maybe they have to move some tables around. But those are the kind of steps that I think reduce the risk of any sort of litigation. And I will also say that if someone in a wheelchair is in an ADA hotel room, I always recommend that the person at the front desk suggest to that, if you have any problem in that room, I don't care what it is, we will take care of it. You call down to the front desk and we'll be on it right away. And I think, again, you're not going to completely eliminate the risk of litigation, but you can reduce it.
I see. So basically it boils down to training of employees.
I think that's important, and I think that is by and large overlooked by many of my clients in the hotel and restaurant industry. I can't speak for larger corporate-owned hotel chains, but I do think some training, for example, the folks that are cleaning rooms, it could be as simple as, the little round table in the hotel room is too close to the bed, and therefore, it seems like a very small thing, but if that wheelchair can't get in between those two, that bed and that table, there's a problem. Well, I don't think it doesn't take a lot of training, but it does take some amount of training to make sure your housekeeping staff is aware of issues like that.
I see. Yes. Training always, I think it's like you mentioned, it's overlooked, especially in non-corporate hotels, as far as cases as ADA compliance. And just like you mentioned, it's very simple, common sense, but often, everybody's so busy that it doesn't even cross our minds to think about the other person that could be in a wheelchair.
I think you're right. I think that, especially in the hotel industry, folks, everybody's working hard and everybody's busy. I think the challenge is finding that 15 to 30 minutes periodically to have very short training sessions. And then I think documenting, whether you're training on ADA or an employment issue, whatever it happens to be, document what you've done, because if litigation does arise, that's a defense that certainly can be effective. If you could say, for example, to a judge, Your Honor, look, we have trained on this issue often, regularly. Here is our training. Yes, we, are we absolutely 100% buttoned up? Maybe not, but we have periodic training, and we also have, for example, housekeeping supervisors that review every room or nearly every room to make sure we're compliant. And I think, the ounce of prevention issue really can help, because once you're served with a complaint, you can bet that it's going to be expensive to resolve it, both because you've got attorney's fees and also because you usually, on average, you have to make some fairly significant changes to your restaurant or hotel to bring it compliant.
Yeah, in our industry especially, there's never too much training. So I really appreciate you giving this advice. And one final question. If I'm a franchisee, do I need to worry about franchisor if I face an ADA case?
Generally speaking, well, let me back up. It probably depends a little bit on the agreement that you have with your franchisor.
Mm-hmm.
That being said, on average, I would say that yes, your franchisor certainly doesn't want to end up with a reputation as someone whose franchisees
mm-hmm.
are sued, whether it's an FLSA case or an ADA case. I would say that franchisors, at least in my experience in the hotel industry, do visit periodically to ensure compliance with ADA and obviously other federal and state laws, whether it's a safety or an OSHA, whatever it happens to be. So, to circle back to your answer, I would say yes, but I'm not aware that there's any formal requirement that a franchisee notify a franchisor unless it's in agreement.
I see. All right, great. As usual, very good insight, Bob. Thank you very much. And if any of our viewers have any questions and they would like to investigate this further, we will have your contact information below. And I would like to mention once again, if you haven't watched the video about FLSA and the minimum exempt salary requirements, we're also going to have the link below. You can go back and watch it. And thank you very much. We really appreciate your time, and we'll see you next time around.
Thanks, Eric. Have a good day.
Great. Thank you very much.
Bye now.